We are streaming. Shannon, put us on the record, please.
Go ahead.
Excuse me. This is a matter of Gibson versus Wagner. Mr. Tom Blasky for the plaintiff, Mr. Jeff Hengeveld for the defendant. And this is the defendant's motion for summary disposition. I have read your submissions, gentlemen, so please be brief. Go ahead, Mr. Hengeveld.
Yes, thank you. And I respect that you've read the submissions and will intend to be brief. I also respect that you presided over the underlying case and the trial therein, so I know you're familiar with certain facts, but I want to highlight a couple of key facts. Before I get to those key facts, of which I think there are four, at I think the last hearing, and it may have even been off the record, the court mentioned that it wanted to know why the barrels were not dug for. And I think the evidence presented in the motion for summary disposition clearly answers that and demonstrates that Mr. Wagner had a good faith and honest belief that there were risks associated with digging for the barrels. The risk analysis that he engaged in is absolutely within what an attorney of ordinary learning, judgment, and skill would do under the same or similar circumstances. Under the Simcoe versus Blake case and its progeny, the attorney, Mr. Wagner's exercise of professional judgment in whether or not to dig for the barrels is clearly protected by the attorney judgment rule, which prevents a claim like Mr. Gibson is bringing in this case. Mr. Gibson, in hindsight, wants to travel down a different road rather than the one he created, and is essentially claiming that Mr. Wagner and Shoemaker, Loop, and Kendrick should have saved him from himself. So with that said, I think we directly answered why the barrels weren't dug for, and I'll get into that in a little bit more in a moment. But I said that there were.
So let me interrupt you here. I did see the opinion letter that he wrote to Mr. Gibson. What I didn't see. And maybe you submitted it and I just missed it. I'm assuming there were some conversations between attorney and client over the pros and cons that were set forth in this letter. What did they testify to as to that? Was it just the letter? And Mr. Gibson said, "Hey, you're the attorney. I'm going to do what you recommend."
No, there were discussions, and I've highlighted that testimony in the motion. Let me grab the transcript and see if I can highlight some of that. But certainly, starting with Mr. Wagner, he testified that he had conversations with Mr. Gibson about the risks associated with digging for barrels. Mr. Blasky had us produce Mr. Wagner's time records, which show and evidence that there were conversations with Mr. Gibson on various occasions. Now, again, that is corroboration with the fact that these discussions happened. Mr. Gibson testified that there were conversations about digging for the barrels. Let me, so that I can note the page and the line. Let me get that. Okay, sorry for that delay. On page 62 of Mr. Gibson's deposition, I asked him, did Shoemaker, Loop, and Kendrick advise you that digging up the barrels might create a release and cause an event that you'd have to report to the MDEQ or EPA? The answer was yes. And I said, and did Shoemaker, Loop, and Kendrick indicate to you that by digging up the barrels, you could exacerbate contamination? Answer, yes. Did Shoemaker, Loop, and Kendrick advise you that by digging for barrels and discovering barrels that you could potentially be liable for remediation? Answer, yes. All of these things go to what Mr. Wagner was most concerned about. If you dig for a barrel and these barrels have been buried there for many years and you puncture a barrel, it's kind of like an eggshell barrel argument where you puncture the barrel, you might create contamination or exacerbation of contamination that flows into the nearby river, and then you're subject to the Clean Water Act reporting requirements. You're also subject to reporting under CERCLA, the environmental law that would apply. And so if you know that you have contamination that is a risk to human health and the environment, that's when you have to affirmatively report that. This isn't sort of some trickeration as the plaintiff's response suggests. This was an analysis where the first kind of undisputed fact that I think we have to put ourselves in agreement on is that there is no question that Mr. Gibson is personally liable for environmental remediations and for any sort of reportable event. So Mr. Wagner, as the lawyer, has a client come to him who has purchased this property in his individual name, has not done a phase 1 or phase 2 environmental study to get a baseline, and also signed contracts that have whereas and as is language that put him personally liable for remediation efforts should a reportable event trigger.
So like what I'm getting at is did the attorney say, all right, Goldie, here's the deal. We can explore, dig up these barrels, find them. That's obviously the easiest way to prove your case, is to actually prove there's barrels there and that there's bad stuff in those barrels. There's some risks with that, and here's the risks if you do that.
He absolutely did that. Undisputed.
Another. Hold on.
Sorry.
But another approach would be, we got the testimony that there's barrels there, and we could try to go forward based on ground penetrating radar or whatever, whatever. But that's really going to be a tough proof issue for the jury. I mean, they're going to have to believe you that these people told you these things, and accept that. All right, radar says it looks like there could be barrels down there, and obviously the downside of that approach is the jury could say, hey, there were barrels, you didn't dig them up, you haven't proved your case, you lose. What do you want me to do? What's your decision, client? Which risk do you want to take? Did that conversation happen?
That advice was in writing before the lawsuit was filed. That's Exhibit C to my motion. Exhibit C is Mr. Wagner's January 8th, 2015 email, where Mr. Wagner lays out the uncertainties in litigation and states that there are significant hurdles to this litigation to proving the claims. Mr. Wagner says the core of the case is proving and demonstrating that what was buried and that it was the Danilowitzes that buried it. That advice is in writing. Now, what Mr. Wagner had to do on a go-forward basis after that email, once the complaint was filed, was gather the evidence as you just suggested, Your Honor. And that evidence, as you know well from the underlying case, was that there was not only Golden Gibson's testimony that Walt Danowitz had told him he buried the barrels that had bad stuff in them, but that he had Kyle Brown and John Stewart, two witnesses to the conversation that Walt Danowitz made those admissions in. Number three, they had Brent Lazarus, who said he was an eyewitness to the barrels being buried on the property. And number four, we had objective evidence from PM Environmental that said we did the ground penetrating radar, and those anomalies are consistent with barrels, so many barrels that we couldn't even count them. Now, that leads me to Exhibit D as in dog to the motion, which is another email, so in writing evidence, where Mr. Wagner informs Mr. Gibson on April 26, 2016, look, and PM Environmental and our environmental attorney at the firm, Mark Mercer, indicates that we could do ground penetrating radar, and that will allow us to determine if there are uncovered conditions in the ground, and it's a non-invasive process. They even attached the PM Environmental scope of service, which explains exactly what's going on and what the GPR, ground penetrating radar, will do. And then Greg Wagner, in his email to Mr. Gibson, states, also, please note the potential for affirmative reporting. We are going to take a phased approach to minimize the exposure, but there is a definite risk moving forward. Now, what Mr. Gibson argues is that we didn't follow through on that phased approach. But that's not accurate, because we had the evidence and there was consideration of whether there was enough evidence to win at trial. Mr. Gibson said he thought he had a strong case going into trial. Mr. Gibson knew all of this evidence. He knew that there could have been digging. He knew that the choice was made not to dig. So, Your Honor, I would suggest the mere fact that this case survived summary disposition period, I know there was no motion filed, but it survived through the summary disposition period, and Your Honor, had it survived all the way to the jury, suggests to me that there was enough evidence to prove the case and prove the claim that survived to the jury. So that leads me to why we're here today. We're here today because in hindsight, Mr. Gibson says, well, no, I don't think any of this whole case should have been brought. I think at the beginning, you should have said, you know what, Mr. Gibson, we don't believe you. We don't believe anything you have. We need to dig for the barrels. And if they would have dug for the barrels, and they would have poked a barrel and caused some contamination, I could see us being right here before Your Honor in a malpractice suit saying you should have advised the client that there were major risks, that this remediation plan now costs hundreds of thousands, if not millions of dollars, because there's contamination of the river and contamination of adjoining property and so on and so forth. So Mr. Wagner then is put in an untenable situation. That's why I think where this leaves us is, number one, there is no breach of duty. Your Honor, he acted, Mr. Wagner, my clients acted as an attorney of ordinary and reasonable skill, care, and discretion would in a same or similar case, or same or similar circumstance. And on top of that, we have, and again, most demonstrated by the emails in writing. So we're not arguing back and forth whether a conversation was had or not. We have in writing before the case was filed and when the PM environmental testing is going on. By the way, Mr. Gibson was present during the testing process. So we have.
So what did they find when they went to look for the barrels?
They found anomalies consistent with barrels, and that was the official expert report by PM Environmental Services.
Well, I know what the ground penetrating radar revealed. Mm-hmm. I heard that at the trial. But my understanding is that subsequently they did do some digging and found something other. Well, they didn't find barrels. I'm curious what they did find.
Yeah, that's set forth in the environmental report that Mr. Blasky's firm had commissioned, which again, that report was actually done after this malpractice lawsuit was filed.
I'm aware of that. I understood that. But I was just curious if ground penetrating radar found anomalies consistent with barrels. I was just curious what the anomalies were. What the defense attorney at trial argued, I think quite effectively, this has been an auto salvage yard for a number of years.
Right.
We shouldn't be surprised that there are metal objects buried on the property. How can you assume those are barrels?
Well, but that's okay. So now we're getting into the weight of the evidence. The weight of the evidence, sure, you can discount PM Environmental's and challenge PM Environmental's opinion. That's fair game. That's what every trial is about. And the jury decides which they, what weight to give that evidence. And so, yes, in this case, it was a weight of the evidence, and you could poke that hole in PM Environmental's opinion. But that's not malpractice. That is, again, going back to attorney discretion and judgment here. Attorney judgment rule says, look, you in good faith and had an honest belief that you were giving advice that would protect the client from risk of environmental remediation plans and environmental reporting. You don't currently have a reporting obligation because you don't currently have knowledge that there's risk to human health and the environment. Again, this is not trickeration. This is if you happen upon evidence of contamination and risk to human or eminent, and I think it's eminent risk to human health and the environment. If you have that knowledge, then you have to report. And then we risk that the MDEQ, which Mr. Gibson had prior dealings with, you risk the EPA, you risk the environmental remediations plan being forced on you.
Sure, and I understand all of that. It doesn't bear on my decision for the motion today. I was just curious, what did they find?
Yeah.
Do you know?
Yeah, I don't want to say nothing, but I guess I have the report here, but I'm not sure that they.
Do you know, Mr. Blasky?
Yes, Judge. The answer is nothing. A few hubcaps.
Yeah.
So this ground penetrating radar disclosed anomalies consistent with barrels, and in fact, they found hubcaps?
Yes.
Maybe you should be suing the ground penetrating radar company.
Well, Judge, we think hubcaps are within the orbit of possibility here. Remember, all they ever said was, quote, consistent with, unquote. They never said they were barrels, and they certainly never said what was in them. And all that had to be done to find out was authorize some digging, a little hand augering, to find out if there was anything there, which is what Mr. Wagner never did.
But maybe Mr. Gibson knew there weren't any barrels there.
No, he
didn't want him to do it.
He didn't know. Remember that there's no evidence of that, Judge. That's pure speculation. No evidence.
Wait a minute. He testified that two different people came to him and told him there were barrels there. Why in the world would the person who sold him this property come to him, admit that he defrauded him in a sale, when in fact there never were any barrels there? What it does to me, it strains Mr. Gibson's credibility desperately.
Judge, I have no way of explaining what Mr. Danilowitz was motivated by or what he was remembering on his deathbed when he made those statements to Mr. Gibson. I don't know. But what I do know is that there was no witness at the trial who actually buried any barrels, who actually buried anything. And even Mr. Danilowitz was not available. Nobody who buried anything was available. If I may, Judge, I want to start at the beginning of what Mr. Hengeveld argued.
Well, let me let
I have-
Mr. Hengeveld finish.
Thank
I'm
you, 'cause
sorry,
I do
thought
have,
he was done.
no problem. I have two more points. I want to talk about, well, actually, doubling up on what Your Honor said. This wasn't a deathbed confession. This was a alleged confession by Walt Danowitz that Mr. Gibson didn't bring up and raise until Mr. Danowitz had passed away. So that's, to me, another distinction that leads to strained credibility of Mr. Gibson. And I asked Mr. Gibson, did Walt Danowitz lie to you? And Mr. Gibson was real cagey about saying he couldn't determine whether or not Walt Danowitz had lied to him. But it does strike me as something you wouldn't lie about, especially when you just got the last dime of paying off the land contract. And then you say, oh, by the way, I've defrauded you. It doesn't make sense. But with that said, let me address the damages here, because Mr. Gibson has set himself up for a windfall. He hasn't paid any of the legal fees that he's seeking in this case, and he has no obligation to pay Jerry Tasker or Sally Ewald, the two people who paid the attorney fees on his behalf. So if Mr. Gibson recovers attorney fees, as he is alleged are damages in this case, Mr. Gibson gets a windfall. I think.
And back up a minute, because I don't understand that.
Yep.
Who paid the legal fees?
So the legal fees were actually paid by two of Mr. Gibson's friends, Jerry Tasker.
Why?
Pays to have good friends, I guess.
I guess.
Jerry Tasker paid the money. Sally Ewald, it was my understanding, may have been a girlfriend of Mr. Gibson, but I asked him, matter of fact, I asked him twice during his deposition, and he reminded me that I'd already asked him that, and he already answered it. He has no obligation to repay Mr. Tasker or Ms. Ewald for any of the fees that they paid. So Mr. Gibson
were they going to get repaid if he won? I mean,
not to my knowledge. He said he has no obligation to repay them. So I don't know why they would pay that on his behalf. But it does set it to me, those are not actual damages that Mr. Gibson has in this case. The second,
and that was all ferreted out in your discovery that he says they paid him. I don't have any obligation to reimburse them. I don't owe anybody any attorney fees other than what the unpaid bill that's being pending.
100%, matter of fact, twice. So 200% testimony at the deposition, and I can cite the line and verse, which I have in the motion. The second thing that Mr. Gibson can't claim damages for, and therefore has no damages, is this sale of the property. He says as a damage model that he allegedly lost money because he sold the property thinking that there was contaminated barrels on it. And I asked him the question, why didn't you have PM Environmental do their further work of excavation to determine whether the barrels were there before you put it up for sale? Answer, I don't have an answer for that. So in other words, Mr. Gibson chose to sell before he had PM Environmental dig for the barrels, but he doesn't have literally an answer for why he did that. So I don't think you can claim as damages that you lost money because you sold it under the idea that you still thought there were barrels there, even though you had the jury verdict saying that they didn't believe your claims and so forth. So without attorney fees as alleged damages and without this alleged losses from the sale of the property, there are no damages. There are no actual damages in this case by Mr. Gibson. And that alone would allow an independent reason for Your Honor to dismiss his claims. The last point
he's still facing the attorney bills that are unsatisfied currently, is he not?
Yep. Yes, Your Honor. And that was going to be my last point, which is now he has about $25,000 or so in unpaid attorney fees. He's obligated to pay those to the firm. And the firm has filed the counterclaim, and I don't think there's any issue. Mr. Gibson has conceded that the services were provided, and therefore I don't think there's a question of fact that the services were provided, and therefore he owes the money for those services. But that's different than claiming as alleged damages the attorney fees that unrelated third parties paid on your behalf. So again, I don't think there's a question of fact here. I think that, Your Honor, both for reasons of attorney judgment rule, the lack of proximate causation, which I set forth in my motion, and the lack of damages are all independent reasons for Your Honor to dismiss this case pursuant to 116C10. And if Your Honor has any further questions or wants me to find the exact testimony that I referenced about the payment to Jerry Tasker and Sally Ewald, I can. I believe it's pages 48 and 49 and 102 of Golden Gibson's deposition, but I can confirm that if Your Honor wishes.
Okay, thank you. Mr. Blasky.
Judge, I want to begin by being sure that we are arguing about the same motion, because Mr. Hengeveld said in his argument, there's no breach of the standard of care. That's not in his motion papers, and there is no record before you on the basis of which you can be asked to make that specific determination. That is, did Mr. Wagner violate or not violate the standard of care? It's important.
Wait a minute. I thought that was the very basis, that because of the attorney judgment rule.
The attorney judgment rule is, I agree that that is part of the motion, and I'm prepared to argue about that. But there's no separate issue, like Mr. Hengeveld said there was, of arguing that there's no breach of the standard of care. Mr. Hengeveld says it's an attorney judgment rule case, and I'm prepared to argue that, and I'm anxious to argue that, Judge. It's just that it's not a separate issue of whether or not he violated the standard of care in an objective way. Mr. Hengeveld included that in his argument, and I don't think it's part of the motion.
Your Honor, and Tom, respectfully, I don't want to interrupt you, but it absolutely is on page 10. My first argument is no breach of duty, and I lay that out. So factually, it is in my brief.
There's no factual basis to support it. You have no testimony, no affidavit that you've offered to the court that says Mr. Wagner complied with the standard of care. None.
Yeah, you're hold on, and you're talking about another attorney's expert opinion.
Right.
Gotcha.
And he hasn't presented any of that. And that's what I'm trying to be sure we're clear about. Let me move to the attorney judgment rule, Judge. I agree with you that that's the heart of the motion, and that's the heart of the decision you're being asked to make today. First, let me point out that the attorney judgment rule still requires the lawyer to comply with the standard of care. I've given you the language from the Supreme Court that says so. And it also requires that the attorney's judgment be made in good faith. And my argument to you here is that on this record, there is plenty of evidence of bad faith on the part of Mr. Wagner in making the decision not to dig for barrels, to find out, to confirm that there were barrels, or to find out what was in them. And the attorney does not get to take advantage of the attorney judgment rule if whatever judgment it was that was made was not made in good faith. Here's the most prominent evidence, which was the only way that there was no good faith. The only way that Mr. Wagner was going to lose this client and therefore lose the opportunity to pursue this case and therefore lose the opportunity to make $150,000 or so of fees from this client was if Mr. Wagner went ahead and dug for barrels and found that there were no barrels or that he couldn't prove what was in them. Actual digging done before this case was filed, this legal malpractice case was filed, revealed no barrels and revealed, therefore, obviously, nothing bad was in any barrels. I've explained it as a decision tree. Mr. Wagner never explained to Mr. Gibson. In fact, Mr. Gibson's description in his deposition was he felt he was being led around by the nose by Mr. Wagner, was that he never once, and there is no evidence in emails, notes, memorandum, or even testimony, that Mr. Wagner said to Mr. Gibson, look, if we dig and there are no barrels, you're not going to pay me any fees. In fact, what Mr.
Is it, well, wait a minute, that's painfully obvious.
Well, it wasn't painfully obvious to Mr. Gibson because Mr. Gibson was told by Mr. Wagner that he had a case that would be won based on the evidence that did not include digging up barrels and did not include finding out what was in them. Mr. Wagner.
Wait a minute. You're telling me Mr. Gibson has testified that Mr. Wagner told him he could win this case?
That, yes, and that he should pursue this case because it was a winner. Judge, the best thing to look at, Mr. Hengeveld and I don't agree on much in this case, but we agree on this. The best thing to look at is Mr. Wagner's email message to Mr. Gibson dated January 8, 2015.
Which one is that? Which exhibit?
Well, it's in the middle of page 6. The relevant part is quoted in my brief. It's also attached as Exhibit 2 in my brief.
Exhibit 2. Okay, hold on. I want to be looking at it. All right, I'm looking at Exhibit 2.
And please find the 6-point case plan under cover of the January 8, 2015 email. And the key part of that email is point 2.
I see that, and it's highlighted. We will eventually have to demonstrate what was buried and when it was buried to prove our case.
Yes. And he explains that they've not conducted testing pre-suit in an effort to keep the cost down, but then goes on to say, in a part that's also highlighted in bold, depending on the progression of the case, we will have to conduct testing. If, as I suspect, defendants continue to deny that any contaminants exist on the property. Judge, that's a promise of testing, which would demonstrate what was buried and when it was buried. And it was a promise which Mr. Wagner did not keep.
Well, it's Mr. Gibson who would be the one that's getting it tested.
Well, he
Mr. Wagner is just his representative. Mr. Gibson would have to pay for that testing.
Mr. Gibson would have to pay for that testing. That's right. And Mr. Gibson did, in fact, pay for the testing that was done before this legal malpractice case was filed. But he says, we will have to conduct this testing. And I'm not saying that Mr. Wagner had to pay for it. All I've ever said is that Mr. Wagner had to assure that it got done. And if you
I don't read that as a promise. I'm sorry. I read that as Mr. Gibson, you and I as your attorney, you as the client, are going to have to demonstrate what was buried to prove the case. That's how
Yes,
I read that.
I read it the same way, but he specifically says we will have to conduct this testing, meaning the testing that will prove what's buried and it would prove that there are barrels and what's in them. As he says in the second sentence.
He lays out the risk. If we don't test, proof gets harder. If we do test and don't find any barrels, you don't have a case. If we do test and find contamination, that might help us win the case, but it's going to make any future sale of this property difficult. That sounds to me like a lawyer who's laying out options for the client, because the lawyer doesn't make that kind of a decision. The client makes the decision. The lawyer advises, the client decides based on the advice.
In this instance, the evidence is that the lawyer made that decision. And the lawyer made that decision, and it was clear that the lawyer was making that decision in the second email after the lawsuit was filed that Mr. Hengeveld mentioned, where Mr. Wagner says to Mr. Gibson, we're going to take a phased approach. And again, he's promising that they're going to go forward with the necessary testing so that they have the ability to demonstrate what was buried and when it was buried in order to prove the case. But Judge, if you disagree and you think that that complies with the standard of care, then perhaps in another day, on the basis of a different record where experts are brought to bear on the matter, you can make that decision. The decision for you today is there an attorney judgment rule defense? And I've laid out the reason why I don't believe that there was a judgment such as Mr. Hengeveld argues for. Number one, I think there was a promise to do certain things in a phased approach, to do testing so that it would be available at the time of trial. And number two, I don't think that the judgment was made in good faith, because the only way that Mr. Wagner could be sure that he and his firm earned the fees is by going ahead without the testing, putting the lawsuit all the way through the end without digging up a single barrel, without having any testing, where anybody could come into court and tell the jury in the trial before you, here's what's there. All they could do was come in and say, well, it's consistent with barrels, which means it might or might not be barrels, and doesn't move the needle in terms of decision by the jury in the underlying case about whether or not there were barrels. And so the testing is crucial here. And it just isn't good faith for the lawyer to engage in a strategy which protects the lawyer's fee first and foremost. And that's the lack of good faith that makes it not applicable on the attorney judgment rule. And in fact, the emails suggest, and the testimony suggests, that there wasn't even such a judgment made. The fact of digging, even if they had dug, it isn't quite as simple as Mr. Hengeveld would have you believe. And Mr. Wagner acknowledged this in his deposition. Even if they dug, hand augured, and punctured an old barrel that still had some bad stuff in it, and even if there was a leak from that old barrel, none of that would trigger a reporting requirement, so says Mr. Wagner. The only way that you trigger a reporting requirement is if there's some way in which you have endangered the public health. And he didn't think, he has admitted in his deposition, that there was anything in those barrels that was going to endanger the public health. And so his elevating the scare of reporting was illusory, was a phantom, was a technique by him to try to persuade Mr. Gibson to stay on track and to continue to pay fees.
Well, part of the advice was you could make things worse by digging if you punctured a barrel. But another part of the advice is you're going to prove there's contamination on your property, and that's going to make it hard to sell. The very knowledge that there's contamination on there is going to trigger a disclosure obligation.
Judge, the analysis that beats that argument is this. Mr. Danilowitz in his estate had $2.7 million. And even though this wasn't an insured risk, that was available. Why is that relevant? Nobody has estimated cleanup costs for this site at above $1.2 million. Not even Mr. Wagner, not even during the time he was in the case. So the point is that there would have been plenty of resource to clean it up if that's what eventuated, if that's what needed to happen. There would have been plenty of resource available. And it wasn't a situation in which there was a seller that didn't have any dough or a buyer that didn't have any dough to clean it up. If it had to be cleaned up, Mr. Danilowitz's estate had plenty of money to do that. So that's also why this risk and worry was kind of a phantom on the part of Mr. Wagner, designed by him to continue to get Mr. Gibson to persist in the case so that he could continue to charge fees. Because this was an hourly fee matter, not a contingency fee matter on the part of Mr. Wagner and his firm. Especially in light of the fact that there was not a single witness who actually buried anything available, and that the most crucial witness, Mr. Danilowitz, was not available, and that was known in the beginning. That raises the importance of digging to find out in some definitive way what was there. And Mr. Gibson interpreted the January 2015 email and the April 2016 email as being commitments to gather the best evidence that was available. And Mr. Gibson has said in response to Mr. Hankeveld's question that Mr. Wagner said, we've got to gather the best evidence that was available. That best evidence was the product of a dig and couldn't be obtained any other way. And although, sure, it's true that they didn't want to incur the cost for Mr. Gibson years before the jury was going to hear the case. By the time April comes around, they say they're going to, April of the following year comes around, they say they're going to do a phased approach, and they still don't do it. At some point, it is not good faith lawyer judgment to continue to withhold what you've led your client to believe you're going to do. That's the fundamental argument. In terms of proximate cause, I understand Mr. Hankeveld's argument to be simply that we haven't demonstrated that we would have won the underlying case if barrels had been dug. And he's correct. We aren't arguing that the underlying case would have been won if they had dug for barrels and found there were no barrels. We are arguing, and our analysis is, that the underlying case wouldn't have been brought if the digging had been done, or if it had been brought in the very early stages and then the digging was done because there was a flat out denial of the fact that there were barrels or that there was anything in them by Mr. White, who was representing the Danilowitz estate, then very well, the case would have been stopped right at that moment. And our analysis is that the damage or harm done to Mr. Gibson here includes all the fees he paid from whenever the jury says the barrels should have been dug at least by this time. Our experts say you don't bring an environmental case like this without digging to find out, to getting that objective evidence. But if a jury says, well, you know, I think it was okay for Mr. Wagner to get started, but surely not to continue beyond the point when he knew that Mr. Danilowicz's estate was going to deny that there were any barrels or deny what was in them. And you're right, Mr. White was very effective at the trial of the underlying case in hammering on those 2 points. 90% of the business of any lawyer who is worthy of the privilege of practicing law is telling their clients they shouldn't do it. And this is one in which classically, Mr. Wagner should have told his client he shouldn't do it. And why isn't that attorney judgment? It's not attorney judgment because there's evidence on this record that the judgment was not made in good faith. And there's evidence on this record that the judgment wasn't even made, that in these emails, as Mr. Gibson interpreted them and believed was going to happen, it was a phased approach. As to damages, it doesn't matter at all who actually paid the bills. And it doesn't matter at all what Mr. Gibson may do or plan to do with proceeds of a case if he should be successful in it. If a plaintiff came to you, Judge, and said, I'm going to bring this case and I'm going to give 100% of the proceeds to charity, you would not let that plaintiff inform the jury, the finder of fact, of their intentions as to what to do with the money. What you need to know to reject Mr. Hegevild's theory is that throughout the case, no matter who was paying the bill, they were billing Mr. Gibson. They still are trying to collect directly from Mr. Gibson on the counterclaim. He's no different than counsel, like I suspect Mr. Hegevild is, who's paid by a third party. In Mr. Hegevild's case, by an insurance company. And you would not let me at trial of this case, and you'd be right to prevent me from doing it, tell the jury for any reason that Mr. Hegeveld is being paid by an insurance company, or for that matter, that Mr. Wagner's obligations, if they find them at trial of the case, are going to be paid by an insurance company. I could not do that. I should not do that. It would be dishonorable and contrary to a long line of Michigan cases that would support my being barred from doing that. I acknowledge that, I understand it, but it's not different when Mr. Gibson got his bills paid by other people for reasons that neither he nor they, frankly, have carefully or clearly articulated, although there is a longstanding relationship between the woman who is involved in the payment. And I haven't probed or sort of gotten into the details of that because they don't matter. Legally, they don't matter. Mr. Gibson was billed all the way through the case. Mr. Gibson saw to it that almost all the way through the case, the bills were paid. Mr. Gibson was billed by the firm after the case is over. Mr. Gibson is now being sued by the firm. They're his obligation. And how he satisfies them or what he intends to do with the fees should he recover them, that's his, well, kind of frankly, his business, and not something that is subject of a motion in this case, or should be. On that, I want to also point out that Mr. Gibson does have sale of property damages because polluted ground is less valuable than non-polluted ground, and there will be experts to say that. And the analysis is that he sold, he did sell the ground that's involved to another business, and the only
he sold a property that was an auto salvage lot for I don't even know how many years, many years. How was it not polluted? How was it not soiled with transmission fluid, motor oil, gasoline, all the stuff that comes from a salvage lot?
Well, there's been
I
no,
can't.
Judge, I don't know the answer to that. What I know is there's been no phase 2 environmental testing, which is how you get the answers to those questions. There's been no phase 2 environmental testing by anybody to know for sure. But you're absolutely right. It has been an auto salvage yard for, I think, at least 4 decades, maybe even 5, before Mr. Gibson sold it. And I'm not arguing that that is unimpactful or lacks impact on potentially the value of the property. But what I am saying is that these barrels where Mr. Wagner argued that Mr. Gibson ought to be paid almost $1 million because of what he thought was the damage to Mr. Gibson and the property, that the presence or absence of these barrels matters much to what the true value of the property is. And Mr. Wagner, had he dug the barrels, could have known, Mr. Gibson could have told anybody who wanted to buy the property, look, we've dug for them and there aren't any barrels, no matter what you hear, or no matter what was.
What kept Mr. Gibson from digging up the barrels himself?
Mr. Wagner.
Or even one, even a single barrel. Okay, you've got ground penetrating radar. It shows you that there's anomalies down there that could be a barrel. You could avoid all of the risk of you go out there and you dig it up yourself.
Judge, the answer is because clients are clients and they do what their lawyers tell them to do. And in this instance, Mr. Wagner was clear with Mr. Gibson, we don't want to dig. Don't dig. But that was only after he had broken his promises to do this phased approach. Would you expect of Mr. Gibson that as a matter of law, on a summary disposition motion, that he go out and do something contrary to the advice of his lawyer? I wouldn't, and I don't think any court should, at least not as a matter of law. If Mr. Hageveld wants to make that argument to a trier of fact at the time of a trial, then so be it. That's of course his judgment and his right to do that. But as a matter of law, should you rule that a client like Mr. Gibson should do that which his lawyer has told him not to do, and that his failure to do it defeats his legal malpractice case? I don't think so.
Well, the dilemma for me is, did the lawyer tell him not to do it, or did the lawyer just simply say, here's the risks of not doing it, and the client made the decision, this is what I want to do?
Mr. Gibson clearly understood that he wasn't supposed to dig. And he understood that after all of these multiple conversations with Mr. Wagner. The dilemma for you, Judge, is, are there fact issues in this case? And I think that your questions have revealed that there are abundant fact issues all over this case, which compel denial of the summary disposition motion. There are fact issues that need to be decided by a jury after a jury hears all of this evidence.
May I respond if Mr. Blasky is finished?
Please do, but I've got some people waiting. They've been there for an hour. I got to move on.
Sure. I just want to address then 2 points. Number one, this Mr. Blasky indicates that this is bad faith by Mr. Wagner because he was stringing along Mr. Gibson to increase his fees. But that only assumes that Mr. Wagner knew that there were no barrels buried. So that's not something that's ever been suggested, that Mr. Wagner knew there was no barrels but was going to somehow string this along and not dig because he knew there were no barrels. To the contrary, Mr. Wagner thought there were barrels that contained bad stuff. Therefore, if we have PM strike a barrel, that could create more problems than there already was. And that leads to Mr. Blasky suggests that because the Danilowitz estates had $2.7 million, that all of this could have been taken care of by the Danilowitz's estate. However, that assumes that you could still convince a jury that it was the Danilowitzes that buried the barrels and not Golden Gibson himself or one of Mr. Gibson's friends or acquaintances who had, he had run the property, been on the property for, over 20 years. So that assumes you could still hook on to Mr. Danilowitz for liability. Now, with that said, we have conclusively, and there's no argument about this, determined that Mr. Gibson is personally liable for any remediation because he did not do a phase 1 and phase 2 and bought the property as is. And the contracts all say we're not going to be liable for any environmental contamination. Finally, and the last point is on damages. It is unlike, first of all, I'm not being paid directly by the insurance company. But secondly, the proceeds, party by a third pay, the payment by a third party is absolutely significant here, and it's unlike payment in a third party about by insurance companies or anything like that presented at trial, because one of the elements of damages here are the payment of attorney fees. So if, as the plaintiff, you never actually paid the attorney fees that you're claiming as damages, why should you be allowed to claim them as actual damages? Now, the significant thing being Mr. Gibson not owing those fees for repayment to the third party. That's the most significant aspect to all of this and why there's no actual damage arising from the attorney fees. If he had an obligation to repay the third party, then you could have a better argument that those attorney fees, regardless of who paid them, are indeed damages. But there are no actual damages relating to attorney fees. And then your last point, Judge, you made for you raised, which is, why didn't Mr. Gibson dig for barrels after he lost the case and before he sold the property? For that matter, he was actually at the PM Environmental ground penetrating radar. If he really wanted to dig for the barrels, he could have said to them, well, let's dig for a barrel. Now, there was a barrel that was located on the property that had already been at the surface. So there was a 55-gallon drum present. So again,
that was offsite.
Well, that was offsite.
Yeah, that was offsite.
But it's another objective piece of evidence. So for those reasons,
let me say this. I am going to deny the motion. I believe that there's a question of fact as to who actually made the decision. I don't think attorneys make decisions like this. I think attorneys advise clients and the client makes the decision. And it's not crystal clear to me here that Mr. Gibson just threw up his hands and said, you're the lawyer, you decide, you do what you think is best here. But I'm going to tell you, I got serious problems with this case, Mr. Blasky. I'm telling you, I think Mr. Gibson probably perjured himself when he testified that Mr. Danilowitz came to him and told him he buried barrels with bad stuff on this property. And there aren't any barrels. There's no way in the world Mr. Danilowitz would come to the guy that he sold this property to, confess something that would create huge potential liability for him if it weren't true. Clearly, it wasn't true. I got serious problems with your client's credibility here. Now, I'm not going to be the trier of fact, but I'm telling you, if I were the trier of fact, I would have serious problems with his credibility. It doesn't fly to me. The whole testimony about Mr. Danilowitz coming to him was hokey as all get out. We got a couple flaky witnesses that are in the room. Why in the world would Mr. Danilowitz pour out his soul in front of these two flaky witnesses? If it truly was genuinely I can't live with this anymore. I've got to clear my conscience. I got to tell you, why in the world would he do it in front of these two flakes? So I only tell you that because even though I'm denying this motion today, I think you got serious problems with the case. You do with that what you will.
Your Honor, we have a June 10th pretrial conference, and if Your Honor is going to have that in person, I'm not physically available to be in person.
Oh, you don't need to be. I'm going to do pretrials by Zoom forever.
Okay.
But I understand your ruling. Do you want to, will the court issue an order? Or do you want me to submit an order?
I don't issue orders in civil cases. Given the prevailing party, you need to submit the order.
Judge, that would have been the custom universally pre-Zoom. In the Zoom era, some courts are, and that's why I was asking you, not because I'm trying to avoid the word.
Well, that's one thing that Zoom hasn't changed in my court.
I understand. We'll take care of the order, and we'll see you on June 10th.
All right. Thank you, gentlemen. Have a good day.
Thank you.
Okay, gentlemen, sorry to keep you waiting. We're still waiting on Ram. I won't try to pronounce the last name.
I didn't try it either.
I am going to ask him how to pronounce it, though. I'm curious. It looks like he's hung up in the joining process. Usually when that happens, the best thing for him to do is to terminate and then try to log in again. But he's definitely hung up in the waiting room. So if you could get him a quick message. Unfortunately, when somebody's hung up in the waiting room, I can't kick him out. The only way that can happen is if he, oh, wait a minute, looks like he's coming in. Hold on. It doesn't show that he's made a connection yet, but at least it's on my screen as opposed to in my waiting room.
I'll try to see if I can reach out to him here.
Oh, looks like we've got an audio connection.
Ram, are you there?
Yes, I'm here. I'll go on mute. I'm sorry.
That's fine.
I'll go on mute. I'm sorry.
Before you do that, could you pronounce your last name, please?
You can call Judge. You can call me Mr. K or K. Just K is enough. It's Kotantaraman. So.
Kotantaraman.
Oh wow, pretty good. You did very well, Judge.
Okay.
Thank you so much. I'll go on mute. Okay.
Yes. Shannon, do you have the full spelling?
Yeah.
Okay. All right. So I'm sorry I kept you waiting so long, gentlemen. I had a lengthy dispositive motion ahead of you. So this is a matter of Wild Wild West tobacco number 28. Are there 27 more?
Well, there's more now, Judge. There's about 35, and they keep getting
okay.
Location. So,
all right. Versus the gentleman who just identified himself. And let's see, we've got Mr. Yaldo for the plaintiff, Mr. Mark Davis for the defendant, and this is defendant's motion for summary disposition. So I have read your submissions, gentlemen. Please be brief. Go ahead, Mr. Davis.
I'm sorry, Your Honor.
This is your motion, isn't it?
Yes, Your Honor.
Go ahead.
Does Your Honor have any specific questions that you'd like me to answer first before I start through?
Well, I guess that my most crucial question would be, you guys are arguing that there's a different agreement that's governing this right of first refusal. How do I resolve that? That sounds like a question of fact to me, and I'm going to have to figure out which is the true agreement. How can I decide this motion when we don't even know what agreement is in place?
Your Honor, two things to point out there. Number one, the agreement that Mr. Yaldo attached to his agreement has no signatures by my clients. It was strictly signed by himself, not by his client only, and no one else. It was a draft agreement. The one that I had submitted was signed by all the parties that were required to sign it, Your Honor. And the other point I would make.
So wait a minute. I was under the impression there was a version of the agreement that was attached to the complaint that in fact was signed by everyone. Am I wrong about that?
No, you're not wrong, Your Honor. If I may, Scott Yaldo for the plaintiff in this case. What happened was the defendants, specifically the gentleman that identified himself, signed it in the wrong place. He signed the last page as opposed to, which had a number of exhibits, as opposed to the last page of the lease where the signature page occurred, or this rather, I should say. But more importantly, that's the version that my client had executed and had initialed by and witnessed by his secretary as set forth in the affidavits that we've attached to our motion, Your Honor. So no, you're not wrong, in short.
So there's a version then of the one that was, does the place where he signed show up in one of the exhibits so you can direct me to it?
So if you look at exhibit number 1, Your Honor.
Hold on. They're not tabs, so I got to make sure I'm looking at the right one. All right, I'm looking at exhibit 1.
And it would be the last page of exhibit 1 before you see the tab for exhibit number 2. And you'll see landlords.
Okay. And let me compare that with where he was supposed to sign.
Which would have been about, let's see how many pages forward. On that same exhibit, it'd be 1, 2, 3, 4. 4 pages ahead of that, if there is such a.
Just before the floor plan.
That is actually just before. Let's just look here. Hang on. I'm sorry. 5. Maybe I'm wrong. 6. 7. Yep. 8. So it would have been 8 pages ahead of the floor plan.
I gotcha. All right. And your contention is that the version that the defendant is proffering is in fact a forged version.
That's correct, Your Honor. And we highlighted a number of reasons why we felt that substantively was forged.
Hold on. I'm sorry. Let me stop you for a minute. I see someone else showed up in the waiting room. Let me bring him in. Joseph Raj, I'm assuming this is on this case?
It is, Your Honor.
All right, let me get him in. I just happened to notice he popped up. Mr. Raj, can you hear me? You'll need to unmute.
Yes, Judge, I'm in.
Okay, thank you. Sorry, I just happened to notice it looked like you arrived a little bit late, so I didn't notice when I let everyone else in. So my apologies.
Thank you, Judge.
Joseph Raj is one of the defendants.
Oh, okay.
That's correct.
Okay, so
Judge.
and I'm sorry, I think I interrupted you as you were answering my question, which was the contention is that the version that the defendant is proffering as the true signed agreement is in fact a forgery, and that this language that says the option disappears if you fail to exercise the right of first refusal was never part of the agreement. Am I correct that that's the position?
That's correct, Your Honor, and it's a one-sentence variation with the two versions.
Yeah, a very crucial one.
Crucial one, which is over here.
Your Honor,
Let me make sure I understand this. If they sell the property pursuant to the right of first refusal, and the option still exists, the buyer's buying subject to the lease.
Right.
The tenant's still going to have an option to purchase at a lower price than what they actually purchased for. So am I at least
100%.
correct that? Okay. So, Mr. Davis, how do I decide a dispositive motion when the very agreement that is at issue is contested?
Two issues, Your Honor. The language doesn't make any difference. The case law says, if you look at the Amico case and the progeny that came after it, said that in order to interpret those provisions in a contract, once the right of first refusal is exercised, then that puts the lessee in the position to either accept the right of first refusal or exercise, or to essentially to let their and move forward that way with the purchase, or the essentially the courts have interpreted that the option agreement, if they don't match, dies at that point. Essentially the option agreement becomes the right of first refusal. And I think Amico is pretty clear, and the other case that I cited in my reply brief are pretty clear, and the language is very similar in those cases, Your Honor.
I confess I didn't read those cases in detail, but that frankly would surprise me.
Well, the point,
if there isn't, because they're two separate provisions. There's an option and there's a right of first refusal. And clearly, if they exercise their right of first refusal, the option at that point becomes meaningless. But if they choose not to exercise it, unless there's language in the paragraph about the right of first refusal that says the option disappears too, I think the option stays alive. I guess
in Amico disagree with you, Your Honor. The reason why they made that point was that exactly the point Your Honor had brought up earlier. What would be the point of having the right of first refusal if only the lessee could then afterwards exercise an option to purchase for less than what the ROFR was? It doesn't make sense. It's incongruent, Your Honor, and that's what the Court of Appeals found.
I don't see them as being incongruent. I guess I'd have to take a closer look at Amico, but that sounds to me like a court rewriting an agreement for a party, which the Michigan Supreme Court definitely frowns upon.
Your Honor, the Amico case was pretty clear. It was almost exactly the same case as this, Your Honor, where the property was actually sold under the ROFR because Amico didn't want to match at that time, and then Amico attempted some years later to exercise the option, and they were turned down. They said no, and that option was terminated once you didn't accept the match the ROFR. It makes sense, Your Honor.
I guess I better read that opinion really closer than I did, because that frankly surprises me.
And
Mr. Yaldo, I do want you to address this issue because I think this is going to make or break what I do with this case. How has Mr. Davis misinterpreted the Amico case?
Well, for one, we have a commercial transaction which both parties are presumed to be on equal footing. We don't have a situation where the property at issue is a residential property that may require different analyses. But more importantly, Amico is not only distinguishable, but it's very distinguishable. Why? Because Amico waited several years to bring an action to enforce an alleged provision in its lease whereby it had the right to purchase the property for a sum certain, which was much lower than what the buyer in that case paid. And mind you, Judge, the buyer had been the owner of record for a number of years before Amico ever came forward. We don't have that circumstance here. What we have is a clearly negotiated right of my client only 4 months prior, when they entered into this lease, that the defendants gave them the right to buy this property for $170,000. This wasn't done several years after the lease was commenced. This was done merely 4 months. And within that 4-month period, they alleged to have received an alleged bona fide offer, which we dispute, that says a purchase price very close to what my client's right to buy it at would have kicked in only 6 months after going into the lease, because the lease indicated that my client couldn't buy the property unless 6 months passed. Well, 4 months into it, they're telling them, we want to buy it. We want to exercise that right. If we close in 2 months from now, because we're required to close after 6 months, no problem. We presume that that was a tax implication for the benefit of the seller, i.e. the landlord, in this case, the defendants. We don't have a problem with that. But we don't have an accepted offer in this case. We have what appears to be a purchase offer that was submitted to the defendants by someone we don't even know, because there's no address associated with it or any identifying information. We have a stamp that looks exactly like the defendant's stamp here, but on behalf of the alleged buyer here. We've never tested the authenticity or the verification or the bona fideness, for lack of a better term, of this offer. We don't know if the defendants have ever accepted, although we suspect they've never accepted it, because if they did accept
I object, Your Honor. I object that
No,
he's actually alleging facts.
Mr. Raj, hold on. Mr. Davis, do you represent both defendants?
I do, Your Honor.
Mr. Raj, I would recommend that you let your lawyer make the arguments. Go ahead, Mr. Yaldo.
Sure.
So I guess I was kind of veering off the legal argument related to the Amico case. So let me go back to that. Aside from the fact that we have very distinguishable facts here, the court made that decision based on extraordinary equitable considerations, mitigating against the enforcement in that particular situation, because of the fact that the closing had already occurred some years before, because of the fact that Amico waited too long to exercise its right. For those reasons, we don't have anything close to that in this case. We're closing, we don't have anyone who's already bought the property that we're suing, because in Amico sued the subsequent buyer of the property. We're suing to enforce a lease agreement with the existing buyer before a transfer has ever occurred. That's what we're doing, and that's how it's distinguishable. But I do agree with you, Your Honor. I would be shocked if two different provisions in a commercial lease are to be interpreted against each other and or would be construed as a waiver of one versus the other. But what's material here is that extra sentence that was placed in one version of the lease that doesn't exist in our client's version, Your Honor. And that is intended to clarify the waiver of that right. If it was automatic and by operation of law, then why would it be included in the subsequent draft of the lease that was proffered by the defendants in this case? It goes contrary here. So
let me stop you both. I'm going to deny the motion for summary disposition on two bases. One is we've got a question of fact of whether this is a bona fide offer in the first place. I can't resolve that at a dispositive motion if there's a contention that it wasn't a bona fide offer. They get an opportunity to explore. Was this a bona fide offer? Was it accepted? I think those raise questions of fact, but and I will take a look at this Amico case, but I on the facts that are in front of me right now, I think it's a crucial difference, which is the governing agreement, and that is a question of fact. So for those two reasons, I'm denying the motion. Mr. Yaldo, you'll submit an order indicating that the motion was denied for the reasons stated on the record.
Very well. Thank you, Your Honor.